Good morning, and thank you, Mr. President, Madam Vice President, and members of the court. It is an honor to appear before you today on behalf of the United States of America. The ongoing conflict in Gaza is a critical issue for the international community. This week, many speakers have focused on the factual circumstances of that conflict. They have voiced significant concerns about the flow of humanitarian assistance into Gaza. You have also heard concerns about Israel's decision to cease engagement with UNRWA. You have heard little, however, about the serious, incredible concerns about Hamas misusing UNRWA's facilities and humanitarian assistance. You have also heard little of Israel's security needs after the terrorist attacks on October 7th, 2023. These security needs persist today. Many hostages, including Americans, are still being wrongfully held in horrendous conditions. These are grave circumstances, and they warrant careful attention. But the General Assembly's expedited request, and therefore this advisory proceeding, focuses solely on a request to identify legal obligations. It is not about adjudicating the facts or determining legal consequences. The United States submits that what is before the court is a legal question consisting of two narrow legal issues, and that the answers are clear under well-established rules of international law. These answers would apply regardless of the particular state under consideration. The first issue focuses on the obligations of an occupying power, and the second focuses on the obligations of a UN member state. Mr. President, members of the court, allow me to first address the obligations of an occupying power to the United Nations, international organizations, and third states with respect to humanitarian assistance. International law does not impose any unqualified obligations on an occupying power regarding all these entities, much less any particular entity. The applicable international rules have been carefully developed through state consent to treaties and customary international law. As the court repeatedly recognized, international humanitarian law is the lex specialis governing the obligation of parties to armed conflict. Within that lex specialis, it is the law of occupation that establishes an occupying power's specific rights and obligations. Before diving into the particular obligations of any occupying power, we should step back to understand the context for why states have agreed to specific rights and duties in occupation law. As the court has previously observed, occupation is a question of fact, and occupation law describes the rights and responsibilities for administering control over occupied territory. An occupying power has obligations related to maintaining public order and safety and protecting the civilian population. It also has the right, while an occupier, to pursue its military objectives and govern enemy territory. In the law of occupation, therefore, military and humanitarian interests converge. This means that where specific provisions of that law call on an occupying power to provide the civilian population with relief, the occupying power does not lose its right to ensure its own security. With this framing in mind, I will address the specific limited obligations of an occupying power toward third states and organizations in two categories. First, obligations on allowing and facilitating relief for the civilian population, and second, rules relating to the impartiality of humanitarian organizations. In both categories, occupation law preserves an occupying power's discretion to address its security interests, including the ability to curtail the activities of third states or organizations that are contrary to its security. For the first category, most submissions to the court address the Fourth Geneva Convention of 1949. Article 59 of the Fourth Geneva Convention states that when the population of the occupied territory, quote, is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by all the means at its disposal. Several submissions incorrectly assert that this means that Article 59 requires an occupying power to agree to all relief offered by all outside organizations. But the text of Article 59 contains no such expansive language, nor does it prescribe which relief schemes an occupying power must consent to. The only mention of third parties comes in the next paragraph of Article 59, which states, quote, such schemes which may be undertaken either by states or by impartial humanitarian organizations, such as the International Committee of the Red Cross, shall consist in particular of the provision of consignments of foodstuffs, medical supplies, and clothing, end quote. The word impartial is obviously important, and I will return to it. But for now, focus on the fact that this provision is actually a definition of what a relief scheme provides. That is, food, medical supplies, and clothing. The language on third parties merely describes possible providers of relief, which is clear from the words may and such as before the example of the International Committee of the Red Cross. It is also critically important that Article 59 does not remove an occupying power's authority to ensure public order and safety in the territory. In other words, an occupying power retains a margin of appreciation concerning which relief schemes to permit. Thus, even if an organization offering relief is an impartial humanitarian organization, and even if it is a major actor, occupation law does not require an occupying power to allow and facilitate that specific actor's relief operations. An occupying power may also fulfill its humanitarian obligations toward the civilian population while advancing its own military and security interests. An example can be found in Article 55 of the Fourth Geneva Convention. Article 55 describes the obligation of an occupying power to ensure the food and medical supplies of the population. But as the ICRC commentary explains, under Article 55, quote, the occupying authorities retain complete freedom of action in regard to this, and are thus in a position to take the circumstances of the moment into account, end quote. Similarly, while Article 63 recognizes that national Red Cross societies and other relief societies are permitted to continue their humanitarian work under Red Cross principles, an occupying power may still impose restrictive measures for urgent reasons of security. I turn now to the second category, which is a fundamentally important limitation built into occupation law. Articles 59 and 61 of the Fourth Geneva Convention make clear that collective relief may be conducted by third states or, quote, impartial humanitarian organizations. As many submissions acknowledge, impartiality requires that humanitarian relief be distributed in a non-discriminatory manner. However, the concept of impartiality in the phrase impartial humanitarian organization also refers to taking no side in the armed conflict. The ICRC commentary to Article 59 makes this clear. It says that, quote, only those states which are neutral are capable of providing the essential guarantees of impartiality, end quote. And the commentary to Article 61 shows that the term impartiality in describing organizations providing relief is synonymous with neutrality. Here, there are serious concerns about UNRWA's impartiality, including information that Hamas has used UNRWA facilities and that UNRWA staff participated in the October 7th terrorist attack against Israel. Israel therefore has ample grounds to question UNRWA's impartiality. Some have argued that the evidence is insufficient, or that the UN's investigation and the Kelowna report have resolved concerns about UNRWA. But the Kelowna report itself recognizes that, quote, neutrality-related issues persist for UNRWA, and that there continue to be serious challenges with respect to UNRWA's oversight and accountability. Again, the court need not and should not reach these factual issues. But given these concerns, it is clear that Israel has no obligation to permit UNRWA specifically to provide humanitarian assistance. UNRWA is not the only option for providing humanitarian assistance in Gaza. In sum, there is no legal requirement that an occupying power permit a specific third state or international organization to conduct activities in occupied territory that would compromise its security interest. To hold otherwise would be contrary to the Fourth Geneva Convention. Mr. President, members of the court, I turn now to the obligations of Israel as a UN member state. The Security Council and General Assembly have worked for decades toward an end to the conflict between Israel and the Palestinians. Throughout that long history, Israel has hosted and engaged with the UN agencies, and UN representatives. Some participants have argued that this engagement has resulted in or arisen out of additional obligations on Israel solely by virtue of Israel's membership in the United Nations. Those arguments rest on mischaracterizations of the UN Charter. The General Assembly does not have the power to impose on Israel a perpetual obligation to cooperate with UNRWA. This is a fundamental principle that is distinct from any obligations Israel or any UN member state might have toward a UN entity that it agrees to host. This is because the UN Charter codifies an allocation of power and responsibilities among its principal organs, particularly between the Security Council and the General Assembly. That allocation was deliberately chosen by the drafters and is central to the United Nations approach to advancing international peace and security. This court's prior opinions, both in competence of the General Assembly and in certain expenses of the United Nations, remind us that in interpreting the Charter, the court considers the relationship that the Charter establishes between the General Assembly and the Security Council. This structure has paramount importance. Yet many arguments in these proceedings would upset this structure, including the suggestion that Article 2, Paragraph 5 of the Charter effectively confers upon the General Assembly powers reserved in the Charter for the Security Council. That is incorrect. Article 2.5 states in relevant part that, quote, all members shall give the United Nations every assistance in any action it takes in accordance with the present Charter. This clause does not mean that resolutions by the General Assembly form binding obligations on member states. The Charter carefully defines the responsibilities that are unique to the Security Council. Under Article 39, only the Security Council can decide what measures, quote, shall be taken by UN member states to maintain or restore international peace and security. And only the Security Council can make the threat determination that must precede such binding decisions. In addition, such decisions require not only that at least 9 Security Council members vote yes, but also that the 5 permanent members either vote yes or abstain. Unlike the Security Council, the recommendations and activities of other UN organs, including the General Assembly, do not themselves have authority to bind UN member states. The Charter is clear as to the limits of the General Assembly's powers. Under Article 10, the General Assembly may make recommendations to the members of the United Nations. And under Article 14, the General Assembly, quote, may recommend measures for the peaceful adjustment of any situation, end quote. In sum, while the General Assembly may make recommendations, it may not order coercive action. Straining international law to expand the General Assembly's powers, as some have suggested here, would serve only to weaken the foundations of international law. This court has also recognized the Security Council's unique role under the UN Charter. For example, in the certain expenses case, the court explained that, quote, it is the Security Council which is given a power to impose an explicit obligation of compliance, end quote. It is only the Security Council which can require enforcement by coercive action, end quote. And the court itself has interpreted action to mean coercive or enforcement actions, as in Article 11, paragraph 2 of the UN Charter. While the court also indicated that measures recommended by the General Assembly under Article 14 implies some kind of action, it did not do so in the context of determining the scope of Article 2.5. Some suggest that Article 2.5 is not limited to enforcement actions by the Security Council, but they do not account for the fact that the Charter does not use the word action in describing the General Assembly's powers to make recommendations on questions relating to the maintenance of international peace and security. Nor do they account for the negotiating history of this article, which is explained in the United States written submission. The attempt to expand Article 2.5's meaning would also be contrary to the practice of the United Nations with respect to other entities that the General Assembly has created. The court emphasized this in the certain expenses case when it pointed to the UN Secretary General's statement that, quote, while the General Assembly is enabled to establish force with the consent of those parties which contribute units to the force, it could not request the force to be stationed or operate on the territory of a given country without the consent of the government of that country. Some have pointed to what they consider to be precedents in arguing for a wider role for the General Assembly, but these are easily distinguishable. The situation here is not parallel to Namibia, where the UN General Assembly acted in conjunction with binding UN Security Council resolutions. Nor does the question before the court involve the responsibilities assigned to the General Assembly, which the court considered in certain expenses. There, the court found that the General Assembly had the power to take decisions to approve the budget of the organization. That case is clearly distinct because the General Assembly was acting under express authorization in the UN Charter to make certain decisions on budgetary matters. The reparations case stands for nothing different. In that case, this court affirmed that the United Nations is an international organization imbued with the powers essential to the discharge of its functions, including the capacity to claim appropriate reparation for damages suffered. The case has been repeatedly cited by the court for that limited proposition. And while the court referred to the importance of Article 2.5 to the effective functioning of the UN, the court expressed no opinion or analysis as to the scope of obligations incurred by the member states under that article. In the reparations case, the Charter was silent on the issue before the court. Yet here, the Charter is clear that the General Assembly lacks the power to impose binding obligations on UN member states. Other participants suggest that the court should interpret Article 2.5 expansively by reference to other articles in the Charter, the principle of good faith or the duty to cooperate. The United States respectfully submits that the court should reject the proposition that Article 2.5 transforms the recommendations of the General Assembly into binding obligations. The obligations under the UN Charter must be implemented in good faith, But good faith does not obligate a UN member state to take specific measures in the absence of a decision by the Security Council that particular action is necessary. In this case, the Security Council has not adopted a binding resolution that Israel must cooperate specifically with UNRWA. Absent such a Security Council decision, individual member states have flexibility to determine appropriate measures consistent with applicable law. They can give due consideration to the recommendations of UN organs, but such recommendations plainly are not binding. The court should also decline to find that a general purpose of the United Nations, such as under Article 1.3 of the Charter, may impose a specific legal obligation on a UN member state. As the court made clear in the certain expenses case, it is necessary to distinguish between the purposes of the United Nations and the powers conferred to effectuate those purposes. These powers are not unlimited. Nor should the court reinterpret Article 2.5 on the basis of Articles 55 or 56 of the Charter. Article 55 provides objectives for the United Nations to promote. Article 56 then provides for a generalized commitment to cooperate with the United Nations in pursuit of the objectives in Article 55. Neither of these articles compels, much less lists, particular actions for the organization or its member states to undertake. These articles were not intended to infringe upon member states' authority to determine how to advance these objectives of the United Nations. Mr. President, members of the court, before I conclude, I would like to make three overarching observations about the question referred to the court in this advisory proceeding. First, it cannot escape notice that the request follows the regrettable precedent of seeking advice with respect to the obligations of only one of the parties to the underlying conflict. We are all well aware that less than a year ago, the court provided its advice on a broad set of questions focused one-sidedly on Israel and its activities. Second, the General Assembly has simply asked the court to identify the obligations of Israel. The narrow framing of the question is important because the court has related contentious proceedings before it, including with Israel as a party. This means that, consistent with the narrow scope of the question, there should be no finding either as to compliance with any obligations identified in this proceeding or as to the legal consequences of any alleged breach. Third, the question is limited to identifying those obligations in relation to the presence and activities of the United Nations, other international organizations, and third states. While there certainly are rules of international law relevant to the population of an occupied territory, those were addressed in the court's July 2024 opinion and do not need to be revisited. Similarly, the court has recently advised on the right to self-determination in this context. The question before it here does not require revisiting the analysis of that right. In concluding my remarks, let's return to the principles I began with. The question before the court in this proceeding is, by definition, a legal question. The General Assembly has asked the court to identify a set of obligations, and that is all. We also urge the court to bear in mind that the rules applicable in this context apply globally and to all states. Some have asked you to identify sui generis responsibilities for Israel, or even a sui generis responsibility tied to UNRWA. Identification of such novel obligations would be inconsistent with international law, including the UN Charter. Novel legal interpretations will not bring an end to the ongoing conflict. They will not bring the hostages home. They will not create a better tomorrow for Israelis, Palestinians, and the region. To be clear, the United States supports the flow of humanitarian aid into Gaza, with safeguards to ensure it is not looted or misused by terrorist groups. We encourage the international community to focus on advancing a ceasefire and on fresh thinking for a better future for Israelis and Palestinians alike. Mr. President, members of the court, this concludes the oral statement of the United States. Thank you for your attention.